Hey everyone, welcome to the search bar. We're talking about how the practice of law has shifted from a professional calling to a complex business model and what that means for the next generation of trial lawyers.
Fast forward 50 years and look what's happening with AI. We have situations where lawyers have submitted briefs which have cases cited that don't exist. So this can too easily become a substitute for the thinking, for the reasoning of the judge, him or her.
In your opinion, what are the most maybe substantial ethical challenges that law firms, attorneys really face today? Hey everyone, welcome to the Search Bar, the podcast for law firm leaders who want smarter growth without the guesswork. Wine optional. I'm Eric Ritter, the SEO sommelier and founder of Digital Neighbor. With more than 12 years of experience helping law firms scale, I'm here to have insightful conversations with industry subject matter experts so you can learn from them. And if you're ready to dominate in today's AI driven search environment, check out my Motion for Marketing Success system. It starts with a free discovery session, no fluff, just a clear path forward. The link is going to be in the show notes. Now to today's episode. I'm super excited. We're looking at the legal profession through the lens that spans over 50 years. We're talking about how the practice of law has shifted from a professional calling to a complex business model and what that means for the next generation of trial lawyers. To help us navigate this, I am joined by Mark Z. Zauderer. Mark is a senior partner at Dorf Nelson and Zauderer LLP and one of New York's most distinguished trial and appellate lawyers. He has represented everyone from Fortune 500 corporations to high-profile public figures. And his new book, Counsel: The Courtroom is Open: Lessons from More Than a Half Century in Law and Life, is hitting the shelves this April, actually April 14th, and I'm super excited about that. Mark, welcome to the Search Bar. Thanks for joining me today.
Thank you. It's good to be with you, Eric. My pleasure.
Awesome. Now, Mark, as the SEO sommelier, I always look for a wine that matches the depth of our guest. Since we are discussing 5 decades of excellence and a career built on robust classic litigation, I thought a vintage Bordeaux was the only right choice. Much like your career, that wine really requires patience to develop, has incredible structure, and only gets more complex and valuable with time.
I think some of those wines have probably aged more than me, so I look forward to trying.
Love it. Well, let's get started here. We often talk about law firms as businesses, but 50 years ago, the engine looked very different. You've seen that transformation from the golden age of partnership to the data driven firms of 2026. So, just curious, in your opinion, Mark, how have private law firms changed most significantly since you first walked into a courtroom?
Well, what you say is very true, Eric. When I started practicing law, no one thought of law firms as being businesses. They were professions, like accounting firms, like medicine. And the for many lawyers, the coin of the realm of success was not money. It was respect in the community, a feeling of service, and that distinguished them from businesses. Businesses most are perfectly ethical. There's nothing wrong with the way they operate, but professions were thought of. They're really the sequels to what hundreds of years ago were the guilds, where professions in Europe, had their own attributes, and were very much earned the respect of the community. So beginning I would say in the 1980s, several things happened. Uh, One, the clients became more and more international. At the same time, law firms were typically single city affairs. And lawyers who came out of law school, many who started at those firms, were imbued with the culture of the firm and the time, or about the time they were eligible to become partners, which traditionally was 8 or 9 years, more or less. The firms were comfortable with them and they were comfortable with the firm. And firms grew as I say, typically in one city, what we say is internally. As businesses began to spread out, law firms to meet their needs, some of these were international transactions, law firms began to grow. But to grow, they grew in a different model. They were no longer homegrown. They typically would look for aggregations of lawyers or law firms to allow them to expand in other cities. And the the uh, the sort of the template for judging whether to have a merger were some very narrow criteria, typically profitability and hours worked by the various lawyers in the firm. And that began to produce changes in the profession, because if lawyers would come from other firms to join a particular firm, they really meant they had no loyalty to their prior firm and no loyalty to their current firm. So if their financial expectations were not met, it could cause breakage in the law firm. The other thing I think happened in parallel was that lawyers, largely through publications like The American Lawyer, began to become aware of what other people, other lawyers were earning, which kind of whetted their appetites. And also in parallel industries such as Wall Street, lawyers began to see in the 1980s the outside salaries that were being paid to people. So I think all of those things came in confluence to produce changes in the profession. Think of a professional, think of the doctor who years ago would make house calls and not go home until the end of the day when he or she had seen every patient. Of course, we don't see that today. I recall seeing a Super Bowl ad a number of years ago for a major accounting firm, which typically was a professional organization. And the ad, for which they paid dearly, said, "We are in the business of accountancy." And I thought about it. Why are they advertising themselves as in the business of accounting and not the profession of accountancy? And I think that's just another illustration of how this trend has affected people in various former professions that we now call businesses. So that's sort of a short description, in my opinion, of what's happened to the profession of law.
Love that. Mark, thank you so much for sharing that. And kind of from your perspective, kind of looking back, I'm curious if there's maybe one thing, I'm using air quotes here, that maybe that those old school firms did better than maybe what we're seeing now in those modern, more tech heavy firms of today.
Well, one thing I think is is measurable, at least it's recognizable, and that is the quality of the product that lawyers turn out in major firms is not as consistent. Because if a firm has grown by aggregating lawyers for whom the template was the amount of business, that at times can obscure whether or not there is the consistent quality. Some of the major, I'm familiar with the New York City law firms. If in a brief, and I'm familiar with litigation, I'm a business litigator primarily, both at trial and appeals. But when I started practice, among certain firms that were known in New York City, if their name was on a brief and you read it, if you were another lawyer, or even I think judges felt this way, it had credibility, and the judges reading the brief would know that the citations are accurate, that they stand for the propositions for which they're cited. Fast forward 50 years, and look what's happening with AI. We have situations where lawyers have submitted briefs uh, which have cases cited that don't exist. But even more subtly, and this happened before the beginning of AI, authorities cited in briefs more frequently did not really stand for the propositions for which they were cited. They were real cases, but when you dig down and you're a judge or another lawyer reading an opponent's brief, you see a proposition cited, and you read the brief, and really it's not only easily distinguishable. It may just be have nothing to do really with the proposition for which it's cited. Again, I think this is one of the unfortunate aspects of the evolution of professionalism in law to the business of law. Look, there are certainly very fine firms with superb lawyers and superb product is out there, but the consistency that once existed, in my opinion, is no longer there.
Wow, that's a great observation, and I don't think anybody besides you, Mark, is kind of in the position to make that observation. So I think that's super valuable, and I appreciate you sharing that here. I have a question here, kind of want to move on, kind of as the business side of law grows, arguably very aggressively, kind of the ethical landscape, right? And you were kind of already hinting at that a little bit, like with the usage of AI and everything out there. It really becomes hard to navigate between the new technology and the pressure for higher realization rates. The stakes really are getting higher and higher. So, in your opinion, what are the most maybe substantial ethical challenges that law firms, attorneys really face today? And, maybe if since you've already shared kind of your perspective, how it's changed over the years, if you have any insight on that as well.
Sure. Well, I think you used a word that's very important, and it makes a nice transition in response to your question, and that is realization. So, with the transition of law practice to the business of law, you find a phenomenon that's very common, which is a law firm, particularly a major law firm with hundreds or even thousands of lawyers. They're always wanting to increase profitability. Well, how do you increase profitability, particularly if your business is time based? Lawyers bill at certain hourly rates. So, what is the gross income of the law firm? It's a product of the hourly rates per lawyer times the number of hours lawyers work times the number of lawyers you have in the firm. And I'm putting aside some of the specialized firms that are business oriented firms that have business clients, but they're on contingencies. But put that aside. But the bulk of work done in these major firms, certainly in the business world, is hourly based in litigation, with which I'm most familiar. So think of this: the firm says we want to increase profitability by 5% next year. Well, how do you get there? You got to get people to work more hours, and you have to adjust your billing rate. That's all you've got. So we see compensation structure change to accommodate that. Associates, which numerically are the bulk of the law, the greatest number of lawyers, they are compensated now on a bonus system, which is, let's say, you have a salary, and if you and they want you to work 2,000 hours minimum. Many firms do it. When I started as an associate at a large firm, we had no specific billable hour quotient. In your annual review, they would know what hours you've worked. We didn't even know the number of hours. I mean, we could have added up our daily timesheets, but nobody, for 365 days, nobody did that. There was not so much emphasis on that. And then when you create a bonus system, which is not only must you bill 2,000 hours, which is hundreds of hours more than were expected when I was a young associate, and you want a bonus, now you have to bill more than 2,000 hours. You have to reach that. You know, let's be charitable and say, lawyers can have differing views of a workday, how many hours they're billing, and it's not a precise number. We don't measure it with a chess clock typically, but it certainly is laying the groundwork for exaggeration in the field. Let's put it that way. If you're a young associate asked to review documents, now we do it electronically. We used to sit in warehouses and have to fly out to the Midwest. For example, from New York, the party that's being on the other side of the case would produce documents in a warehouse in Kansas in the winter, and they turn off the heat. So you go in there with 3 layers of clothing. Now everybody can do this in their pajamas because all this information is electronic, and emails are the heart of this discovery lawyers are familiar with. But if you're a young lawyer off on assignment, and it takes 12 days, you're reviewing documents. Oh, are you working 8 hours? Are you working 6 hours? What if you, have a phone call from somebody and 2 people could work what appear to be the same day. One says, "Well, I worked 6 hours." I says, "Well, I really worked 9 hours." And I'm not saying lawyers are dishonest, but the financial requirements that are being imposed by the law firm really put pressure on lawyers because they have a minimum, or they're told at their annual review, you didn't meet your minimum. And a significant part of the hoped for compensation is bonuses, which may only be a lawyers only eligible for if they exceed a certain number of hours. So that becomes an ethical issue. That was really the beginning of your question. You
Yeah.
know, why judge time? Am I being honest about the time that I'm putting in on an assignment?
Yeah, no, I that's such a great perspective and kind of, I can that's a great visual, right? Like being out in Kansas in a warehouse wearing 3 layers of clothing, right? And, nowadays, like you said, you're in pajamas in your bed going through Discovery through your emails, you know?
Yeah, in those days, I had my document review clothes.
You gotta have a
And
special wardrobe, yeah.
you got it. When you have to, put up with all the dust.
Yeah. Love that. Well, let's talk a little bit more about AI because you've just seen so many different pivots, so many different shifts there. And so you mentioned, hallucinations from the AI, where the citations are made up. But really with the rise of AI and talking about ethics here and even automated drafting, where do you see that biggest trap or the biggest trap doors maybe for a lawyer's professional reputation today?
Yeah. I think this is potentially pernicious, the use of AI, and let me in a way that I don't see being discussed a lot. If you're drafting something, you could use AI, you edit it, but ultimately it's your product. And where I think we haven't really identified the problem sufficiently. Suppose you're the judge, and you're using AI to come to a decision. So, and I think this is happening. So the judge or the law clerk, who's kind of laying the foundation for the judge, puts the fact pattern and what the arguments are, the legal arguments, the fact arguments, into the computer, into AI. And what comes out is a decision based on what the input is. So this can too easily become a substitute for the thinking, for the reasoning of the judge, him or herself. And this is why we have judges from different backgrounds. They bring different perspectives, but they bring their own perspective to a decision in situations where the result is fuzzy or it's not clear what the result would be. It's what judges do at their best, which is use their experience to take a series of facts and legal principles and come to a fair and just result. Now, if that's left to an algorithm and the judge signs the name, you know, on it, we have now substituted AI for human judgment. That's my concern.
I can see that absolutely, that we're handing it off, right? We're already seeing it. I don't know if you saw there was an interesting video where they had a deposition of the Doge people who decided on the grants, right? If it's DEI or not. And basically, they were feeding it into ChatGPT and then just reading the summary in ChatGPT and making their decision based on that. So they were already letting exactly what you're talking about, right? Is already happening, at the federal level, which is, scary to see.
Yeah, I did not see that, but I'm not surprised based on what you just related.
Yeah. Or you get a bunch of 21, 22-year-olds, right, that are straight out of college, and they're gonna start using the technology that's available to them.
Straight in college. Funny you mentioned that. Uh, I was talking to a young man who's a couple years out of college who works in my office, not a lawyer, who's just out of college. And my book, Courtroom, the Counsel is Open, or Counsel, the Courtroom's Open. I got it backwards. That's the book, which you say it's being released on April 14th. and distributed by Simon and Schuster. It'll be widely available. It's available now for pre-order if you don't mind my plugging, because I think
Of
it's an interesting
course. No, I think
reading.
everybody should get it. Yes.
But but it also, I think the way this book was produced shows how law practice has changed. When I got out of law school, I clerked for a federal judge, and I went to work for a large law firm. We started our day. I remember the day I walked into my office, and every office was furnished the same way. It had a desk, 2 chairs, a telephone, and a dictating machine. Not like the little handheld ones that we may have become familiar with, but it was a big unit and had a 3-inch belt. And if you were asked to produce something, you had a choice. You could dictate this machine and call down to what was called the steno pool. It was a collection of secretaries, and there was only very, very crude word processing. Big machines would have wills and templates for corporate documents. So, uh, or you could ask for a stenographer to come to your office and dictate live. Well, I tried dictation, both with the belt and the stenographer, and I learned it. It's like learning a language when you're young. It's very easy, right? You can't learn languages so easily, when you're a teenager. I dictate everything. So I dictated my book largely from my car to my assistant over the telephone. I edited it after it was printed out. Uh, Practice has changed in that regard. Uh, and uh, so coming back to the story I was going to tell you about the young man in my office. So we were talking about how the book was produced. I said I dictated it. So I said, well, how did you do your papers in college? Did you write it longhand and have somebody type it if you're not a good typist? Or did you type it yourself? People know typing from the time they're 3-year-olds today because they have computers. Went to high school. There were 2 tracks. There was sort of the college track, and then there was the commercial track, so you'd learn typing. But okay, everybody learns to type. He said, no, I don't do either. I don't write. He says, we use AI. I said, what, your college papers? What about your term papers? He says, well, everybody uses AI. So hard to believe, but are we now in a situation where across the country and thousands of colleges and hundreds of thousands of students, everybody's just having their papers turned in on AI? I understand there's some monitoring this, but I'm sure the kids are clever enough in most instances to get around it.
Yeah. It's really, really interesting to kind of see, what that's gonna kind of bring to the future workforce, as you mentioned, people straight out of college doing that, is concerning. And I wanna come back kinda to your book and kind of in line with this, Mark, is, the lessons, in your book are invaluable. So I'm just curious if you're mentoring someone today, let's say a junior associate, someone just starting, at your firm there at Dorf, Nelson, and Zauderer today, is there anything timeless maybe, something, more foundational from a skill level, they need that AI or technology won't be able to replace?
You know, I think for me, the key is professionalism, meaning, and by the way, if you go online, put in Mark Zauderer just on Google, I don't put very much on Facebook, and I'm like, all I see is on these sites, people say, I've honored to have been with so and so, and basically promoting themselves. I'm happy to suggest the book. By the way, any profits from the book are going to my son's charity, which is called Grassroots Grocery, which in the New York area, they distribute food to people in need in New York City, particularly in the Bronx, which is a somewhat underserved area. Uh, and the book, as I say, is
Amazing.
Counsel, the courtroom's open. If you put my name in Google, that'll come up, and some recent interviews I've done on PBS television on some of the issues in the book, including some of the things that we've talked about today. Just we'll put my name in Google, and you'll see, for example, the address I gave at a law school where I talked about professionalism at the commencement address in New York. And, it involves a number of the book outlines it. I think people will find it helpful, particularly people who are looking for mentoring. but it has elements which I think the most important elements are be true to yourself. If you speak at all, speak the truth. Um, have respect for people and listen. Listening is a trait that is probably more valuable than talking because it's by listening that we know what to say. And I've seen people talk past each other too often in court and in life. I think that's important. And it involves civility as a professional, meaning a lawyer. You may you may to slay the adversary's case, but you don't have to slay your adversary. So it's a learned profession, and we don't learn everything we should know in law school. We're put out sometimes in a trial by fire. We're at a deposition. One of our early experiences, we're given the responsibility, and the lawyer on the other side of the case is extremely experienced and gets aggressive. How do you handle that? Well, you have to be true to yourself. There's certain principles and guidelines. We have in New York a series of what I call precatory guidelines that are part of our regulatory rules. They're not the basis of sanctions because we want them followed without punishment. I was actually chairing a section of the New York State Bar Association. We presented those to the administration, the administrators of the courts in New York, and they've been adopted. And other jurisdictions, thankfully, have done the same thing. And they've provided for lawyers these civility guidelines, which are part of professionalism. And I'd like to think they're taking hold, at least to some extent.
That's amazing. That's very cool. I wanna, talk a little bit more, as we're kind of looking into the future and kind of talking about the future kind of the legal environment. And, you obviously as a litigator, from your perspective, I'm curious, do you think that the era of the generalist, maybe that great generalist litigator is over? Or is it maybe even more valuable than it was before?
I think the opposite. Well, I think that no, I think you're right. The era of the generalist, I won't say will disappear, but what we have seen over the last few decades uh, is specialization. We don't, by the way, in New York, we don't say we're specialists. The the authorities have determined that that's not an appropriate word to use. We say we concentrate in a particular area, but it's the same thing substantively. Um, Laws become complicated. Uh, there are more and more statutes, different jurisdictions. You can be in New York, and there's a legal question. Well, it could be state law that's applicable, could be city law, it could be federal law, um, and as more and more problems in society or issues in the different areas of our lives uh, are subject to regulation, uh, to statutory changes. It's very difficult for somebody to be a master of all trades. I take that to heart. You know, I've among many cases I've argued appeals on in the past decade. Let's say, for example, are real estate cases, very complicated real estate cases. But if a client came to me and said, "Can you do a house closing for me?" I wouldn't know how to do it. I wouldn't trust myself
Yeah,
because the biggest danger in to me in practicing law uh, is not knowing what you don't know. If I knew what I didn't know, I can go to someone else and get the answer or get guidance. But if I handle a transaction and I'm not aware that there's something relevant that I don't know, I could be committing malpractice, and
for
and
sure.
nobody wants to do that.
Yeah, and I'm sure, you've probably gotten that in your life. I hear that a lot where someone hears like, "Oh, you're an attorney. Can you help me give me some divorce advice? Like when I'm going through my divorce, what should I be doing here?"
That happens
Yeah.
to me when I sit down in a coffee shop or even on a subway train in New York, but it happens to all of us. So well, particularly if I'm wearing a suit and tie, I'm getting stared at these days because nobody's I didn't just put this on for the interview.
Yeah.
I mean, it's not comfortable
It's the uniform, right?
uniform, but
Yeah.
also uniforms are okay, you know?
Yeah.
Uniforms are not just for others, but for yourself. It's who you feel you are, you know? That's my view. It's funny, I often commute by train from a suburb. It's a 32-minute train ride into Manhattan in New York City. I started doing that in 1990 when I moved to the suburbs. And it's largely a white collar community, finance, business, law. Uh, and so I'd go on the train platform. Everybody had a jacket and tie. Today, I'm probably the only one, and the same community. It's a culture change, but I think we're all better off if we are who we are. You know, I've got some ties, they've gotten wider, narrower, so they change. I've got some, I don't think this one, but I have ties that I probably went out of fashion in 1985, but I brought them back. I still wear them. So,
Always comes around. Yeah.
I don't have to change the heels on my shoes, people do that, every 2 years or change with but that's okay. I think people are have their own views on those things, but I'm comfortable with that.
I couldn't agree more. And Mark, this was fantastic. And I just want to thank you so much for being on and sharing all these great insights. It's really rare to get perspective that covers so much ground. And your career is just a real testament to why the human side of law still matters. And before we wrap, is there any final, maybe piece of advice or any final thought you want to give to our listeners out there?
Well, certainly in the practice of law, one of the things that I have been most grateful for is the opportunity to have started a law firm many years ago from after being an associate at a large firm and remembering the feeling of a Friday afternoon when my paycheck stopped and our new firm with there were 5 of us. It's in the book. I go through it. I think there's a little bit of humor in there. In counsel, the courtroom is open. By the way, I should have mentioned you can pre-order. If you go to the website, Simon& and Schuster, counsel, the courtroom's open. It's pre-order. You could order it from Target, Walmart, Amazon, all of that. But in any event, it was the feeling of showing up in my new rented office on Monday and suddenly realizing if we don't find it, we don't eat. We had no clients, but we had enthusiasm, and there's no better motivator than fear. So it can be a very valuable emotion. And fortunately, step by step, things worked out. And I do take the reader through that sort of progress, what happened, what some of the challenges were, and I think it's something that could be of interest to people not only in law, but other fields. And like everything that you read or you hear from other people, you have to put it through your own filter. Certain things are right for you, certain things are not. And I've talked with other lawyers about this. I think we are all products of mentoring from different people, not just one person. And we've kind of taken from each person that which is meaningful to us. So with that, I really thank you, and I thank your listeners or viewers for
Yeah.
their interest in these subjects and any contribution I have made to their thinking. I'm grateful for that.
Absolutely. And I can't wait to check out your book myself. Again, that's Counsel. The Courtroom is Open. And I think, even for someone like me who's not in the legal space, but who works with a lot of people in the legal space, I think that entrepreneurial journey you just described will really hit home. So I recommend everybody go out there and check out the book. It's available for pre order or order now. And when you read it, leave a review, right? 5-star reviews help more people discover the book as well. So make sure you're reviewing it as well. And to our listeners, viewers out there, if you're ready to scale smarter, not harder, book a free discovery session with me through the Motion for Marketing Success System. The link will be in the show notes. Until next time, stay curious, stay grounded, keep building a law practice you genuinely love. Mark, thank you so much for joining.
My pleasure. Good to talk to you.
Cheers, everyone.